Alrighty, so I think that we can begin. I will be admitting people as they come in. Usually with these things, we have a few late stragglers. So I will hand it off to the Hamilton Community Legal Clinic to begin their presentation.
I have to unmute myself. Perfect. Thank you so much for having us and for inviting us to attend today. I'm going to start off by sharing my screen. Just click that. And I believe now that you can see, hopefully this works. Okay, so as long as everyone can see that. So we are here to present on tenant rights and housing law in Ontario, specifically some issues that we've been talking with your admin about, your student union about, issues related to student tenancies and things that may come up, and we do have our presentation plan, but we have time for questions at the end. So please feel free to ask away. We do put a couple disclaimers at the front end of our presentation. The first being that the information that's contained in this presentation is current as of today's date. So especially with the last year and with COVID-19, there's been so much changing, as everyone's aware, and especially with laws and regulations. There's been a lot that's changed within housing law too in the last year, and a lot that's going to be changing as well. So the information that is presented today is current to now. And as well, the other disclaimer that we put out is when we give legal information sessions, we are providing legal information, so we're not providing legal advice. And the difference is kind of legal information can apply generally to different situations, and it's general information, whereas legal advice is specific to your particular questions and circumstances. And so if you do have questions about, a specific issue with a tenancy or with, an application for housing or something like that, please feel free to reach out to us. We at the Hamilton Legal Clinic are available in a few different ways. We are available by phone, by email, and we have our website as well. So feel free to email us with any specific questions. We have an intake process where we have housing lawyers that will that are dedicated to answering calls each day. So usually when you call in, we'll get back to you within 1 or 2 days. So that's kind of our turnaround time for answers to questions. So if you have any specific questions related to your situation, give us a call or an email. We are limited with our in-person service right now just because of COVID-19. We have some, service by appointment only though. So give us a call or an email first. And then to kind of start off, I wanted to ground, the presentation in the law of that governs housing in Ontario. So the first thing is that the Residential Tenancies Act, the RTA, is this legislation that governs landlord and tenant relationships in Ontario. So if you are a tenant or a landlord in a landlord and tenant relationship, you are likely covered by this act. You're not always covered by this act, and we can talk about that exception, some of those exceptions there, but generally that's the law that covers them. And the Landlord and Tenant Board is the tribunal that has the exclusive jurisdiction to apply that law, to apply the RTA. And orders from the Landlord and Tenant Board are legally binding, and they have the same effect as if they were issued by a court. So it's essentially the Housing Court of Ontario. And a landlord and tenant generally don't have enforcement rights in the small claims court, but there's some exceptions in certain situations where you do go to small claims court. Again, we advise to get legal advice if you're wondering which place to go to. The Landlord and Tenant Board is also the only authority that can authorize evictions, except for in very specific circumstances. And when we're talking about tenancies in this case, we are talking about residential tenancies, of course, meaning, where you live and where you're at home, not a commercial tenancy. A commercial tenancy is very different. That is a whole other legislation. So the LTB is the only one that can authorize residential evictions. And then a fixed term tenancy is an agreement to live in a place for a certain amount of time. And a lease is a written tenancy agreement that governs the relationship between the parties, between the landlord and the tenant. And then the term, what we call, the term of the lease, we talk about the length of time for a rental agreement. And finally, we have our final definition, joint tenants. So that's where there's a single tenancy agreement amongst multiple tenants, and each tenant is jointly and severably liable for the payment of the entire unit. So that's kind of a very specific legal situation, but basically what it means is that there's one an agreement for one place to live, and multiple tenants are on the same lease, so that each of them is liable for their individual part, but also for the entire part if something goes wrong, basically. And we'll go more into that in our presentation. So yes, we talked about a little bit about the RTA already. So it's about the rights and responsibilities of landlords and tenants who rent residential properties in Ontario. The purpose of the Act is to protect tenants from unlawful rent increases and unlawful evictions, and also to establish a framework for the regulation of residential rents, to balance rights and responsibilities of landlords and tenants, to set out, what rights the tenant has as well, and enforcing those, the method for adjudication of disputes and for enforcement of orders, and for informal processes to resolve disputes as well. So I talked about before that not all tenancies are subject to the RTA. So that means that some tenancies, unfortunately, are a little bit more precarious. Tenants who share a kitchen or a bathroom with their landlord, or an immediate family member of their landlord, are not subject to the RTA. And this is really, this is a real loophole in the law, to be honest, where if you do share a kitchen or bathroom with a landlord, you have very little rights compared to very little enforceable rights to prevent an eviction and enforce your rights, really, than tenants who are protected by the RTA. So if that is your circumstance, or if you're going to go into that circumstance, it's fine. You just know, kind of what you're getting into. And if you'd like, more specific advice on what that means, again, feel free to give us a call. And now I'm going to turn it over to Chanel to talk about tenant rights and responsibilities.
Perfect. Thank you.
So if you just want to let me know when to turn the slide. Yeah.
Thank you so much. So I'll be talking a little bit more about specific rights that you might have as a tenant and responsibilities of tenants and landlords as well. Okay, perfect. So tenant rights under the RTA, repairs and maintenance. So it's your landlord's job to repair and maintain your unit. Landlords must fix or replace anything that is in bad condition or doesn't work properly. This includes things that come with your place, so appliances like a stove or a fridge. And if you live in an apartment building, this includes common areas such as parking lots, elevators, hallways. Landlords also have a responsibility to stop pests such as mice, bed bugs, or cockroaches from entering your unit, or to get rid of them if they are already in your unit. It doesn't matter if your lease or rental agreement says something else or otherwise, and it also does not matter if the problem, you were aware of it when you agreed to rent the place. Next slide. Thank you. Just continuing, tenants are responsible for the ordinary cleanliness of their own unit. If you rent a whole house, the law is unclear about who's responsible for outdoor work, such as lawn mowing or snow shoveling. Tenants are also typically responsible for their own belongings, such as furniture, clothing, or electronics. Your landlord might be responsible if it is their fault that your things are damaged. Tenants also have a responsibility to inform the landlord of issues that arise in their unit or residential complex, so within the building, or if you live in maybe a townhome, so the residential complex. Next slide. Thank you. So another right under the RTA is reasonable enjoyment of the rental unit. So a landlord must not substantially interfere with the tenant's reasonable enjoyment of the rental unit through harassment or interference with vital services. Landlords also have a duty to accommodate protected grounds under the Human Rights Code. Tenants also have a right to privacy in their units. Typically, landlords must provide tenants with around 24 hours written notice before entering the unit. So I'm just moving on to leases in Ontario. So the Ontario Standard Lease, so the Ontario government has a standard lease form that most landlords must use for tenancy agreements signed on or after April 30th, 2018. You can't force the landlord to use the standard lease form, but the law gives you certain rights if they choose not to use that. You can find the standard lease form on the Ontario Ministry of Housing website. Both the tenant and the landlord must sign the lease no later than the day the tenant is supposed to move in. The landlord must also give the tenant a copy within 21 days after the tenant signs the lease and gives it to the landlord. If you've signed a tenancy agreement already and it was not on the standard lease form, or if you've made a verbal or written agreement, consider requesting in writing that the landlord provide you with a lease on this form. Next slide, perfect. And so this is just a picture of the top of the standard lease. And so it goes on for many more pages and it kind of has specific parts, and you can take a look if you wanted to go on the Ontario Ministry of Housing website. So what terms can't be put into a lease? So no pet clauses, except for rules set out in condominium bylaws. So typically they can't say you can't have a pet. Penalties for paying your rent late or for breaking the landlord's rules, extra fees if you have children, pets, or visitors, requirements for post-dated checks or a damage deposit, terms which make you responsible for repairs and maintenance. If any of these terms are in your rental agreement, the landlord can't make you follow them, even if you sign. It's really important that you ensure your agreements cover details in writing, so in the future, there's no disagreement of what and who is responsible. It's important to indicate who pays for utilities, indicate if parking is included or if it's not included, indicate the length of the lease, indicate the amount paid for rent, or if there's any discounts or penalties, and indicate the day in which you can move in. Be sure to have a copy of the signed rental agreement. The law says the landlord must give you a copy of the signed agreement 21 days after you've signed it. So what can a landlord ask for in lease applications? So when you're applying for a lease or you're looking into renting something, what's allowed to be asked essentially? So they can ask what your income is, if you work, where you work, how many people will be living with you, the names of the people living with you, if you have pets, if you smoke, permission to do a credit check, references from past landlords, or if you have a guarantor or cosigner. So some things that a landlord can't ask for in rental applications: if you're pregnant or if you have children, if you plan to have children, or if you already have children, if you plan to have more, if you're married, single, or divorced, your religion or ethnic background, your sexual orientation, if you receive welfare or public assistance, if you have a disability, your age, if you are a Canadian citizen. Thank you. I'm just going to pass it over to Katie.
Perfect. All right. Thank you, Chanel. Excuse me. So now we're going to go into group leases, which often happens with, in student housing, where you sign a lease with a group of people because you're, renting a home. So the RTA doesn't really say a lot about rights and responsibilities in terms of roommates between roommates. The RTA really covers the landlord and the tenant relationship, which is also why you want to make sure that you have a relationship that's legally binding with the landlord. So that's why we advise that all roommates or housemates sign a lease with the landlord specifically. And if you are a roommate that's coming into a situation that you don't have a direct relationship with the landlord, you're not protected by the RTA, and your rights are more limited. So again, we encourage you to have a lease specifically with the landlord so that you have that legally binding relationship and you can kind of benefit from the rights of the RTA. So the RTA states that the landlords only have to recognize tenants that they know of and approve of. So again, that's where that relationship comes in, where if they don't have a legal relationship with a roommate, they are not legally required to recognize them, and the tenant's not able to enforce their rights because they're not a legal tenant, they're a roommate. And so you do have to get approval, to be a tenant with the landlord. Yeah, so if you sign a lease with the landlord and your roommate or housemate doesn't pay their rent, you may have to pay it. So that comes into play when you have a joint lease that, like a group lease that doesn't specifically say which amount each tenant is paying. So again, either having a specific lease just with yourself and the landlord saying, I'm just going to pay this amount and it's for your specific agreement, or if it is a group lease, to specifically note and delineate what amount each tenant is paying is really important, so that that's the only amount you can be held responsible for. Otherwise, you could be liable to pay the entire rent if, say, a few tenants move out, and the remaining tenants could be liable for that whole amount of rent. And yeah, that's where if they leave without giving notice, and without kind of following the proper steps, the other tenants could unfortunately be in the situation of being responsible for the whole lease. And yeah, we just advise that, since the law isn't clear about the obligations of roommates and housemates, and since it is kind of a more tenuous relationship, we just advise to think about, who you're entering this type of relationship with, the type of arrangement, and just be careful and watch out. And we just want to make sure everyone's legally protected. And that's what, having the lease with the landlord will do. And some roommates do enter into roommate agreements that outline terms, conditions, and responsibilities that are agreed upon, by each resident of the rental unit. And that's something that you can do, and set out kind of the terms that you are renting it by, and all of that. And that wouldn't be, again, that would be outside of the RTA. It's just something that would protect you more on a small claims court situation, but it would provide some legal protection. So another question, another kind of topic that we wanted to cover is ending your tenancy, or also called breaking your lease. Something that's come up a lot, especially with COVID-19 and with not needing, necessarily student, housing in the city that you're going to school in, because because school has been online a lot. We've gotten a lot of questions about breaking your lease and kind of what that looks like and what the options are. So we wanted to go through those with you to make sure that everyone's kind of on the same page as to what your options are if you need to kind of get out of release, or if you're able to get out of release. So it's a lot of information, but if you have a fixed term tenancy in a lease, you have to give the landlord at least 60 days notice before you end the lease. So you have to use an N9 form, which is a form that's found on the Landlord and Tenant Board website. And it says that you want to end your tenancy and move out. This is 60 days to the end of the term. So it's 60 days before that lease would end. So the lease ends, March 30th, and you give the N9 2 months before that. So you can also make an agreement with your landlord to end the tenancy early if the landlord agrees, and then you can sign an N11 agreement. We would advise, if there is an agreement to end the tenancy early, that you do sign this N11, because that limits your liability, which is a great legal word, for your responsibility for paying essentially the remainder of your rent. So it ends your obligation to pay rent, basically. You may want to ask the landlord if you're able to assign your unit to another tenant. So this means that you would be moving out of the unit and they would be taking over your lease. You're able to do this. You're able to request it. The landlord is not able to unreasonably withhold their consent. So that's kind of a technical term, that there may be a reasonable withholding of consent to an assignment or a sublet. But if you have questions about that, can get pretty technical. So I'd advise to call for legal advice. When you do assign your unit, you're leaving the unit and they're taking over your lease. So that means that you're not responsible if the new tenant causes damage or owes rent, because they're the one who's stepping into your shoes as the tenant, and they have the relationship with the landlord. You no longer have a relationship because you've assigned your unit to the new tenant. And with the assignment, again, you're not moving back in later. You're moving out and you're on your way. The second option that some folks use as well is to sublet their apartment, or sublet their unit, sublet their room, or whatever the case may be. There's a couple rules with this as well. So this is where you are moving back in after the sublet period is over. You can't charge the subtenant a higher rent than the landlord charges you. So essentially you can't profit off of it. And you may have to pay if the subtenant causes damage or doesn't pay rent. And that's because your relationship with the landlord is still continuing. And they haven't stepped into your shoes as taking over the lease. They're just occupying it for a certain amount of time with that subtenancy agreement. So yeah, again, with these situations, if you'd like legal advice, please reach out. And the other issue is, which we hope doesn't, come up and isn't something that people face, but unfortunately we know sometimes it is, when your landlord is, harassing you, refusing to fix serious problems, or interfering with vital services like utility, water, heat, things like that. You can ask the landlord and tenant board to end your tenancy early too. And that would be done through either a T2 or a T6 form to the landlord and tenant board. And if you are in that situation again, I'd advise to get legal advice. So next up is taking action. So this is if you need to take action to enforce the rights and responsibilities under the Act. So to enforce your tenant rights, your right to reasonable enjoyment, your right to, the landlord's obligation to maintain the unit. The first kind of step that we always advise with law, documentation is everything. So we advise to collect evidence first, photos, video, text, emails, and work orders. You can write a demand letter to your landlord, and we always advise to keep a copy so you have a written paper trail. And again, that's the main thing too, is if your landlord is, refusing to talk or refusing to, email or write, through text or something, we always advise to take notes of your conversations, to kind of try and follow up with an email or something to put something in writing. To the landlord, so you have a paper copy of, the steps that you've taken to enforce your rights, and then to also establish timelines for work to be done, and if those timelines are not met, follow up and potentially involve public authorities, so like Hamilton bylaw enforcement, if there are, maintenance or repair issues in the unit, public health or the electrical safety authority, depending on what the issue is. And yeah, again, we definitely advise to get legal advice if you are in a situation where your landlord is not respecting your rights, and to, get advice on whether or not you should file an application, what type of application to file, and the steps to do that. And then just briefly, we wanted to just touch on evictions at the landlord and tenant board. And so there is a process that's outlined in the RTA when you're pursuing eviction of a tenant. And so only the landlord and tenant board has the authority to issue an eviction of a residential tenant. And only the sheriff, as the court enforcement officer, has the authority to change the locks on a unit door or enforce an eviction order that's issued by the LTP. So basically what that means is that if a landlord were to change your locks as a tenant or deny you entry to the unit, that's considered an unlawful eviction. And there are steps that you can take to enforce your rights. And we would advise definitely, if you're in that situation, to call us, and we can help with, an application to the board and potentially an emergency situation to, get you back in, or whatever the case may be, or to prevent that unlawful eviction. And if they're threatening that too, definitely call us, because that's a situation where we would want to get involved beforehand to try and advise them of the law and, prevent anything like this from happening. And so then we'll end with some resources. So yeah, you have the right to file an application against your landlord to claim. So there's different remedies that you can claim. You can ask for landlords to do the work that isn't being done to maintain the unit. You can ask for compensation in terms of, a rent abatement, so a portion of your rent back. You can ask for, various remedies, expenses, things like that, depending on the case. And you can take a look at our website, the landlord and tenant board website, or there is a great website called Steps to Justice that goes through housing law topics and kind of guides you through. There's a couple guided pathways that are for specific types of applications, but they also have good general legal information too. And then there's Legal Line, And then our clinic as well. As I said, we're open for intake every day, and we advise you to call or email to get advice and potential representation. We generally are limited in terms of our funding to representation for eviction, but we are always able to give advice on any kind of housing issue that relates to the areas we practice, and we're also able to give general information and legal advice on different issues, even if we're not able to represent. And yeah, so that's kind of it for today. And all of our conversations are private and confidential. We're a free legal service. We give free legal advice. And when we do the representation portion, that's where we get into income testing, where we do have financial guidelines that we are limited by. But we always can give advice. So we always encourage you to give us a call if you have any questions.